the first of the Marshall trilogy, otherwise known sometimes as the Cherokee cases, although only 2 of them dealt with the Cherokees. First started off in 1823 with Johnson versus McIntosh. Remember what's the lesson of Johnson versus McIntosh? Basically, that American Indian tribes, I say indigenous people here, but I really mean American Indian tribes, federally recognized Indian tribes, retain a right of occupancy until aboriginal title is extinguished, and that can only be done, that is, the extinguishment of aboriginal title can only be done when the federal government takes the land from the aboriginal people, okay? And they can do that in 2 ways. They can purchase it, or they can take it, all right, and take it outright. As I've said, in the cases where they have taken it outright, the United States has tried to settle scores numerous times, beginning with the Indian Claims Commission and later through other settlements. We talked a little bit about the Lakota rightful claim to the Black Hills, and in 1980 the federal government offered $200 million to compensate them for that loss. They refused the money and therefore had still maintained that claim. So essentially what I want you to know from this is not so much that the government can take the land through purchase or conquest, but the government, the United States federal government, going back to something referred to as the Doctrine of Discovery, has, and through Congress's plenary power, has the exclusive right to extinguish Indian title. In other words, to take land that's, that is rightfully claimed by an Indian tribe and declare it no longer claimed by an Indian tribe. And that takes place typically through some kind of compensation in a treaty or an agreement. After 1871, they're all called agreements. So aboriginal title is something that we can refer to around the world. In the United States, aboriginal title is referred to as original Indian title. Okay? It's just a difference in semantics. But the idea is that the sovereign has the exclusive right to take that land. Individuals cannot, other countries cannot. All right? That's just part of the rule book in this case. We also mentioned, talked a little bit about this idea of a pendulum of federal policy, federal Indian policy. And the point I wanted to make was that even though we have, often we have presidential elections that dramatically change the politics of the White House, the United States federal system is intentionally slow to have change. It's designed not to change very quickly. So we have bicameral, Congress, the bicameral legislative branch that has offset voting, and because of that, it's very difficult for massive radical changes to take place. So under the United States Constitution, even though we have some of those changes happening every now and then, they don't always lead to dramatic shifts in U.S. Indian policy. Nevertheless, we do have some periods when U.S. Indian policy is going along one direction and it just seems to take a 180-degree turn and go back the other direction. And what I mean is that we may be in a policy era where assimilation and the reduction of Indian culture is a goal, or seems to be a goal, and then all of a sudden it will turn around and Indian sovereignty will be upheld and Indian Native American cultures will be promoted, okay? And that's happened several times. We can't really say that each one of those times has been associated with a change in politics, and certainly not just a change in Congress or a change in the president. Okay, second case, the second of the Marshall trilogy is the Cherokee Nation versus Georgia. What do you remember about this? This was it was not really a Supreme Court case. It went to the Supreme Court, but the Supreme Court never heard it. And Marshall rendered his opinion, an opinion about why it denied to hear, it decided not to hear this case, and that's because the Cherokee Nation approached the federal government as an independent foreign state. And John Marshall said, no, American Indian tribes are domestic and dependent. They're neither foreign and they're neither independent. So they are domestic and dependent, not international and independent. And they're nations, they're not states. They're nations of people. That means that they are subservient to the federal government in ultimate terms, yet they have the right to exist as a polity. They have the right to exist as a political entity, as a nation of people who ought to have a right to govern themselves. And for that reason, the Cherokee Nation versus Georgia case basically gave, it pretty much established Indian sovereignty in terms of a right to self-government. And it, for the most part, established an obligation by the federal government to serve as the trustee of Indian land. In other words, the federal government would become the great father, and the Indians would become the wards, or the tribes would become the wards of the great father, excuse me. Now, so the Cherokee Nation versus Georgia gets, like I said, it's kind of a double-edged sword. It upholds the right of tribes to exist and to govern themselves, but it denies tribes the existence in the form of a state, in the form of a territorial entity, only a national entity, a group of people rather than a territory. And it also established an obligation for what we call the trust relationship. The federal government has a legal obligation and a moral obligation to protect American Indian assets, in particular American Indian land, from being encroached upon or overrun or exploited by non-Indians. Okay? So this established a lot of precedents, and the Cherokee Nation versus Georgia, Johnson versus McIntosh, are working sort of off of each other. Cherokee Nation versus Georgia is working off of Johnson versus McIntosh. Johnson versus McIntosh tells us that American Indians as individuals can't sell land to individual Americans. Indian tribes cannot sell land to individual Americans. Only the federal government can acquire Indian land or land with aboriginal title, and only the federal government can extinguish that aboriginal title and eliminate it forever. And only the federal government, later on we'll find out, can reinstate the trust land status. Only the federal government can reinstate American Indian trust land. But actually that's a little bit different because it's not aboriginal title. Okay, the third of the Marshall trilogy, this is the one you haven't seen, is Worcester versus Georgia. Samuel, I guess we maybe talked about this. Samuel Worcester was a missionary, maybe we did. And this case came right after Cherokee Nation versus Georgia in 1832. Again, well, Georgia lost the case. And as I maybe hopefully explained, Georgia was asserting its legal authority over land that had not been ceded by the Cherokee Nation. It was not, it was still Indian country. So this is probably one of the most important ones when it comes to defining Indian country, Worcester versus Georgia. Indian country is off limits basically to the regulation by the states. That's what this case really amounted to. Worcester versus Georgia established a very important legal boundary between the authority of states and the authorities of tribes. Tribes are, for the most part, outside of the purview of state regulation unless the federal government gives the states purview over Indian country. And that has happened, as in this little note at the very end, PL 280 or PL 83280, Public Law 83280, which came about in the 1950s. So we'll talk about that later. Okay. So the tribal state exclusion is where many of the things that we're going to be talking about in the class derive from. So it often is the case that states want to regulate something that's going on in Indian country, and the tribes know that they're not allowed to do that. Or tribes attempt to do something that states consider to be their prerogative, their purview, their regulatory territory, and it winds up being that we have a new court case, we have something new to think about and to define. In many ways, Indian law is very, very much a frontier still, so it's still being worked out, it's still being hammered out. All right, now this is a map, a set of maps, I think I showed it to you, that shows the white areas are areas where Indian or Aboriginal title, original Indian title has been extinguished. Original Indian title has been extinguished in this white areas, and what you're left with on this map is Indian reservations, Osage County, for example, in Oklahoma. So Indian reservations showing up on this map, and of course we've already had a discussion about Indian country and reservations, whether they're formal or informal reservations, exist in Oklahoma at a much larger scale, okay, meaning that you have to really blow the map up to see them. They wouldn't show up here, and they're not necessarily officially called reservations, but they are essentially the same thing. Indian individual trust lands are like little miniature reservations in a sense. We don't see them on this map. But the extinguishment of Aboriginal title, original Indian title, is something that only the federal government can do. In a previous class, I was talking about the Wichita, or the Caddoan-speaking peoples that inhabited much of Oklahoma prior to the arrival of the 5 civilized tribes in the 1830s. And those Wichita or Caddoan-speaking peoples had trade relationships with the French, and they were pretty much, their lands were ceded through treaties prior to they were ceded by treaty to the federal government, and the federal government then established, it removed that Aboriginal title, and then they removed the 5 tribes to what is today eastern and southern Oklahoma. So they established title and created something that was actually quite different. We'll talk about their differences as well. Okay, so new stuff today. We've talked a little bit about how European property rights existed. I think we actually saw this slide already. Yeah, we did. It's a little elongated in this case, but keep in mind that the American sort of myth or mythos is that American Indians, were not attached to territory, that they, for the most part, were, the popular view was that these are people who are not farmers, so they're not attached to property, and they are often nomadic, and so they can, they can't really claim the property. Of course, that's all false. We know that there are plenty of examples of not just nations claiming territory, and the United States working to eliminate their claims to the territory legally, but also individual property was common. So we've already seen that. Now, I didn't talk about this, so I want to talk a little bit about this. I want to take one example of property rights within an individual tribe. And here we have an example of the Cherokees, the Cherokee land tenure system, right? And there are different types of land tenure. We've talked a little bit about it. For the most part, what we are used to in the United States is a type of land tenure that we would refer to as fee simple title land tenure. And it doesn't really describe it very much, but in a sense, it's simple in that it's clear-cut. Ownership of land is determined by this changing of hands and a record of changing of hands. And that record of land exchange in whatever instruments they may be, quitclaim deeds or patents or whatever, that form of land ownership is something that the Europeans, particularly the British, brought to the New World. They established this system, which land becomes basically a commodity. Land is something that can be bought and sold, or it can be passed to heirs, to people who inherit it. And those people have a legal title to that land. They have an exclusive legal title to the land. They can do with it what they please. It's an old American tradition, all right? At least not a Native American tradition, but anyway, in Native American societies like the Cherokee, before removal and after removal, they had a system of land tenure that would be referred to as usufructory or usufruct. We'll just say usufruct. So a usufruct tenure system comes from the root words users and fruits. So in other words, under a usufruct land tenure system, people have the right to claim and enjoy possession of a parcel of land as long as they are deriving a profit of some sort from it. In other words, they're deriving an income or a livelihood from it. They're using it to produce something, crops, or maybe they're leasing it out for pasture or something like that, or they're controlling the entry to this area. As long as they're somehow controlling, or they have a claim, a legitimate, obvious, visible claim to the land, then those users are allowed to claim the land. It's only when they abandon it that anybody else can come in and take it. And how do other people take it? They establish improvements or claim the land with fields and crops and livestock and that sort of thing. So it's, for the most part, first come, first serve, use it or lose it, okay? First come, first serve, use it or lose it. How is fee simple title different than that? One of the big problems that, or at least something that people like Thomas Jefferson viewed as a problem, was the tendency for those who own property, those who own land, to hold the land without using it. Hold title to the land without putting it into productivity, with the expectation that eventually, over time, they could sell the land to someone else who did want to use it for a price that was a lot higher than what they paid. Okay? This is called buying low and selling high, and this is what you do in real estate, right? So buying low and selling high, there's nothing necessarily bad with that from a classical liberal standpoint. Classical liberal in the sense of an economic liberal. But to people like Jefferson and other founding fathers, that slowed development, and it slowed, it really went against the whole idea of land ownership, at least in Jefferson's mind. And the idea was that, if people had the opportunity to purchase large amounts of land and just hold on to it, they were speculating, okay? So the term land speculation is a negative one. Of course, these days, all of us who have a retirement account are speculating in stocks and whatever else. we're hoping for, we're buying low and hoping to sell high someday. But in Jefferson's day, taking land and holding on to it specifically and not allowing it to be used was counterproductive to the justification for republic and that sort of thing. So it was really looked down upon. And there were some areas like the Hudson Valley of New York and other parts of in French Canada where large land holdings had actually been taken up by aristocratic individuals, people that had good political connections, and they just held on to them and never allowed the land to become productive and fruitful. Okay, so that was in some ways kind of a problem because in the Hudson Valley of New York, what happened was you had an economy that developed. An agricultural economy that developed on land that people didn't own. And if they didn't own it, then they typically didn't take very good care of it. They exploited it. So this is the problem. This is one of the problems associated with land speculation that founding fathers generally wanted to avoid. So fee simple land title gives you exclusive control over the land. In the case of usufruct land tenure, you have a use right, or you have a property right based on not a title, not because you purchased it, not because you inherited it, but only because you're actually using it. So it's very different from a fee simple system. Okay? All right, before I move on, any questions about that? All right, so we've got the one type of land, fee simple title, what we're probably used to in the United States, that can be, can make land a commodity that just sits there and maybe increases in value over time, but doesn't necessarily produce economically. And then we have another type that this type of land tenure system really cannot be turned into a commodity, right? Because if anybody's not using it, that means anybody else can come claim it and utilize it. Now, the other side of that, of course, is that in a case of usufructory land tenure, you might be subject to something like the tragedy of the commons. Hunter, you remember that? Alex, you remember that term? Tragedy of the commons? So in that case, you've got the tragedy of the commons situation is when you've got a resource that's not claimed clearly in terms of property rights by anybody. And that means anybody can come in and perhaps take it or exploit it. And so what you have when you don't have very clear property rights, as you do in marine fisheries, if you don't have really clear property rights, then resources can be depleted very rapidly. So that's a very negative part of this sort of land tenure system. All right. Now you can actually go to the library and you can check out a series of volumes, a series of books on Cherokee land laws, Cherokee land tenure laws. And these are the land tenure laws that they put into place back in Georgia and Tennessee, and then they moved them to Indian Territory. They had land use regulations that people had to follow. And the example for usufruct, for example, is for claiming land, anybody who built an improvement, that is, they maybe cultivated a field, fenced a pasture, or built a home or an agricultural outbuilding or something, that was considered a legitimate improvement to the land. Okay, they actually use that term, improvement. In other words, they had placed energy and money and effort into changing the value of the land, changing affecting the value of the land. And if you remember back, John Locke, an old English philosopher, utilized that as his basis of reasoning for claiming property. If you've put your blood, sweat, and tears into changing something on the surface of the earth, then you have a natural right, if natural rights exist, a natural right to that property, okay? Unless somebody else already has title to it. So that's the idea, that you would have the right to claim that land. And so in the Cherokee example, in the Cherokee Nation, if you built let's say you built a built a fence around a cultivated field, then you also have the right to claim land within 1/4 of a mile of that improvement. Or if you built a house or a barn, you have the right to claim land within a 1/4 mile radius of that field or that building or whatever. And no one else then, that created a situation of exclusive use. No one else who may have the right to claim land could do so any more than a 1/4 mile away. Okay, so it kind of dispersed settlement, but it kept people from having property boundary disputes because there was no real property boundary so much. There was no title to the land. If somebody left, somebody died, somebody abandoned a farm, somebody else could take it over and reclaim that status. So that's usufruct land tenure. All right. And some other examples of regulation that the Cherokees had. They had what they called legal fences. So if you just went out and threw up whatever you could, that didn't always count as a fence. You had to have a certain dimension to the fence. Had to be so many feet high. I think it was like 4 feet tall, and it had to be fairly sturdy. They also had regulations on land use. A lot of times, people would set fire to the woods during the wintertime and during the summertime. We've talked a little bit about that. And Native American practice goes way back. It's not just a Native American practice. People are firing the woods in the Amazon these last few weeks. But anyway, the firing of the woods was actually regulated so that during the dry winter season in eastern Oklahoma, people didn't set the forest on fire. Okay, so they had some land use regulations, and these were just some of them. You had others for livestock and that sort of thing. Okay, so what I'd like to kind of wrap up with then is looking at some property rights issues, and we can look at some examples of how federal Supreme Court decisions sort of erode existing tribal rights. So in the case of Johnson versus McIntosh, remember John Marshall, Chief Justice John Marshall, could have recognized tribes' ability to hold their land in a common estate, what we might call fee simple absolute. Right? In other words, John Marshall may, we're not really sure. This is somewhat arbitrary, but obviously it has some kind of reasoning. But Marshall decided that Indian tribes, maybe could have held their land like a family would hold land. Okay? But in the case of Johnson versus McIntosh, Chief Justice John Marshall, he didn't recognize those tribal claims to land as property to states. He recognized them as just land that they were utilizing. So what resulted is the existence of aboriginal title as we know it. Aboriginal title is only a right of occupancy that came to be known as Indian title. A right of occupancy only. So this court case made tidal waves in terms of the future. It really set the stage. Rather than native peoples having rights to land in the same way that a family would have the rights to land that they owned, it was not considered. They were considered to have just a usufruct control of So let's talk a little bit more about original Indian title, otherwise known as aboriginal title. John Marshall, largely, is the inventor of this for the most part. And his reasoning comes from this recognition of European states as having authority over the land. So without that existence of the doctrine of discovery, that England and France and Spain and the Netherlands would have the legitimate claim to areas, to large areas of continent. Without that, this really makes no sense, but and it still may not make sense to a lot of Native American people. But basically it goes like this. Aboriginal title is merely a right of the tribe to occupy, that is, reside upon and use the land. Now, I underline tribe for a reason. As I said, this class is about Indian tribes. It's not about Native American people. Indian tribes exist, in a sense, in a relationship with the federal government. Federally recognized tribes do. So, Indian title only refers to the right of the tribe, not of an individual Indian who is a member of the tribe. And, okay, well, anyway, so almost never an individual right, only tribes are recognized. And the land that, what does that mean? Default of land not disposed of by the federal government. Oh, yeah. So if the United States federal government or a previous colonial power had not taken the land through a treaty or by conquest, if it hadn't cleared that title yet, it still exists. There is no terra nullius in North America, okay? There is no square inch of the continent that is not claimed or was not claimed by one group or another at one time. And because of that, the United States is obligated to clear the title of all that land, wherever it may be. And there still are some areas that, there's questions about whether or not the land has been cleared of Indian title or extinguished of Indian title. So this is not a property right. Thus, there's no right to dispose of the land. Aboriginal title, as we saw in Johnson versus McIntosh, Aboriginal title can't be extinguished by a member of a tribe selling land to a non-Indian. That doesn't clear the title. It can only be cleared by this power of the Doctrine of Discovery, by the European power, or the heir to the European power, in the case of the United States. Okay, so the United States, and before Great Britain, held what is referred to as an indisputable exclusive title. So now we've got original Indian title, same as Aboriginal title. We've got exclusive title, which is recognizing the Doctrine of Discovery. Okay? And the Indian title then is the default status. Okay? It's the default status. If the land has not been taken from the tribe, then it's assumed that it is still under original Indian title. Well, that's about it. So Indian title can only be extinguished with a formal cession of land or purchase, or by taking, by conquest, or eminent domain or whatever. Eminent domain requires to be purchased. So a taking or a cession, these are both important terms. Cession takes place with a treaty. Taking takes place with, General Custer and land, gold rushes and that sort of thing. So the Aboriginal title is equivalent to just the right of occupancy, but occupancy means a lot. In other words, occupancy is something that precedes the United States. It precedes Great Britain, and therefore it has a special status. And we'll talk about what that means through the course. Now, the other thing that we can say is that Aboriginal title, original Indian title, unfortunately is those occupancy rights under aboriginal title are not protected by the Fifth Amendment. So what does that mean? Okay, Fifth Amendment. Anybody, any experts on the Fifth Amendment? You say no, I'll take the Fifth on that one. All right. Yeah, so the Fifth, we all know that, right? The Fifth, taking the Fifth is not self-incrimination, right? It's also that amendment that requires just compensation. So if the government takes your property, then you're owed just compensation or fair market value for the taking. There are a lot of people that used to own homes over here north of OSU campus, and they sold them. They didn't necessarily sell them voluntarily, but they sold them. And it was kind of an interesting case because the university used its presence as a public entity, as sort of the general welfare of the public, to assert eminent domain and force those people to sell. Okay, and yeah.
Is that the same thing that's happening over here by the garage where they cleared all those houses?
I reckon so. It's happened around this campus and every other campus for a long time. I can remember before Boone Pickens handed lots of money to the university to buy that and make it a Olympic Village thing, that the same thing happens over here in residential areas for parking lots. So, eminent domain, okay, well, some people might say, fantastic, I'll get twice as much as I will on the market for it. But then other people will say, I don't want to sell my house, never did want to, I don't want twice the value for it. And they sit on it until they get 3 times the value for it, and then they say, well, okay, maybe. But, that's the whole idea. You have to be compensated, fair market value. In the case of the government, so-called government, taking your land. But not in the case of aboriginal title. Not in the case of aboriginal title. That's not protected under the Constitution, not protected by the Fifth Amendment. That is, the occupancy rights may exist, but if they're lost, then you can't really calculate a value necessarily for occupancy. That's kind of a good thing and a bad thing for Native American people. And it's kind of a good thing in the sense that when it comes to certain types of use rights and certain types of natural resources, what it means is Native American people, tribal members, really cannot be denied those resources. Okay? You know what I'm talking about? No. Hunting and fishing rights for the most part. Okay? Resources that aren't really locked in place, like say coal beds or in the water, that sort of thing. Water is not locked in place necessarily. So some resources are mobile, some resources are moving around all the time. And that occupancy right often is durable in the case of things like hunting and fishing rights. Native peoples generally win when it comes to questions over hunting rights, okay? Which I think is pretty interesting. All right, let's go back to that term recognized title. Recognized title is the term that refers to typically the very first treaties that remove a group of people that cede land and then recognize an exchange of some sort. So the very earliest ones, in the case of the Cherokees and the Creeks and the Choctaws and the Chickasaws, those early 4 were different from others, and Seminoles as well. And there are some other examples in the case of the Iroquois, who made large cessions of land early on with the agreement to exchange lands elsewhere. In other words, the federal government, when it was first trying out its process of taking lands from Indians, from the tribes, it created a pretty decent deal. It constituted the earliest treaties of removal, 5 civilized tribes in Indian Territory, constituted a contractual exchange, and that resulted in recognized title and property rights that were superior to the rights of occupancy. Okay? That's a really important part of this whole lecture. So try to recall that. Let's let that soak in for just a minute. Basically what that means is the federal government, when it first started doing this, said, okay, we're going to take this land, and we know it's your aboriginal home. It's your land rightfully, but we've got to have it. So we know this is your land, but what we're going to do is we're going to take what you had here, and we're just going to take some other land from some other tribes over here. We're going to pay them for it. We're going to set it down here, and we're going to say that your land is now located here. So we're going to legally remove that aboriginal title over to this, and we're going to create a new type of landholding that was close, as close as you can get to an estate, a fee simple type of estate. So that's what made the 5 tribes of Indian Territory so different in terms of their land holding from all other Indian tribes, except maybe the Iroquois and a couple others. But they're the big ones. And basically, this created this recognized title, and that gave a superior property right to the 5 tribes, that those Indians who, after a while, the federal government realized its mistake, and the federal government created these reservations. The 5 civilized tribes' lands in Indian Territory, established in the 1820s and 1830s, were not reservations in the usual term reservation, as we'll see. They were estates. They were landed estates. And that's why their history is a little bit different than most other native peoples, native tribes. All right, so that's kind of what this whole slide explains. So as compensation for those eastern land cessions, the federal government basically did a property switch, and it granted those tribes real property. To do that, it had to extinguish aboriginal title from the Caddo and the Osage, primarily the Osages, and they removed, they went to reservations, and then the United States granted patents, that's the key word really, a patent to those tribes that essentially was like a big, massive estate. So the tribe got a patent, or basically a title in common, just as a big family, to these large estates. And that's what makes Indian Territory different than the rest of Indian country. It is protected by the Fifth Amendment. So if you're interested in Indian country, Oklahoma is one of the most interesting places to be. 5 tribe property is property in the American sense. Okay? Any questions over this? I'll put all this online, so you don't need it online, so you don't need to worry about copying and all that stuff. Okay, so to go from pretty PowerPoint to ugly Brad scribbles, okay? Another point of that is that if you've probably heard of the Allotment Act, the Dawes General Allotment Act of 1887. If you haven't, you will. But more than likely, if you've taken this class, you've probably heard of that before. And essentially, this is what most people will assume, eliminated the reservations. What it really did was it made one reservation into hundreds or thousands of little reservations, and then opened up lands that we called surplus lands to white settlement. In the case of 5 civilized tribes, it couldn't do that. And this is the sort of the proof in the pudding for what I said on the previous slide right here. In the case of the 5 civilized tribes, they were exempted from the Dawes Act because they had recognized title over their lands. And their aboriginal title had been transferred into this recognized title in this, what we might call a land swap, due to the language of the treaties that they had. They had good treaties. So their western land was legally equivalent to the eastern homeland. It was not reservation land. And that meant that, let's go back here, that meant that when, any other Indian reservation, I think I'm going to just kind of stop with that because it's a good place to stop. But any other reservation land is what we call trust land. It's owned by the federal government in trust for the use of Indian tribes. Aboriginal title may exist, may not exist, but it's not recognized title. It's a reservation. And that means that the federal government can determine that it can take it away. And that's what happened with allotment outside of Indian territory. Allotment outside of Indian territory was a way for non-Indians to get that reservation land. And the way that they did that was they said, okay, we're basically going to give all the individuals within the tribe a homestead, or something like a homestead, and then that's going to free up 95% of the land in the reservation. The United States would just say, that's ours now, and they would allow it to be settled by non-Indians. So that was the process that was allowed under this other system, or this later system. Okay. So, well, I guess we could go on. Since the Doctrine of Discovery, we'll just maybe end with this. The Doctrine of Discovery is something that was developed very early on by a Spanish philosopher to justify European overseas colonization. What it really means is that European claims to these newly discovered lands allowed for European powers to claim those lands and then to extinguish Indian title. So this goes, Marshall is working on this theory of the Doctrine of Discovery, that the Europeans had this right to do so. And of course, it doesn't take very long to think about this to realize that that's pretty much arbitrary. Right? The Europeans decided they were going to take it, and that's it. And so we're working under all that. We have to understand that it's all based on this assumption that the Europeans had that right in the first place. So that's probably enough. Yeah, of course it's ethnocentric. But it was, for the most part, upheld in Johnson versus McIntosh, and we've been working with it ever since. So no individual Indian can extinguish Indian title. It has to be a government-to-government thing. And I'm about out of juice, so I think it's probably a good time. If you'll have any questions, we could have a discussion. If not, we'll continue on later. And I'm going to, for the rest of the time until the exam on September 26th, Thursday, September 26th, we're going to look at the evolution of Indian policy, beginning with the reservation period, or actually the removal period. So treaties, removals, reservations, allotment. Then we get into a 180-degree turnaround of the Indian New Deal and the revival of Indian tribal governments. And then we get into the 1950s, late 40s and 50s, we get into the Indian Claims Commission. We'll get into the period of termination and PL 280. And then we get into the Civil Rights Movement and the revival of of Native identity. And in 1970 is when things really changed. So we're just about 50 years away from the beginning of the current Native American Indian policy that we're in now, which is referred to as the era of sovereignty and self-determination. Okay, so we've been in that era for quite a long time now, and probably stay in it for a while. So I'll see you on Tuesday, and I'm going to throw some readings at you, I promise. But otherwise, you can check this stuff out online. Okay? Have a good weekend and go Pokes.